Welcome to another episode of the Functioning Law Podcast. Today we are exploring some key aspects of the English law of tort. We're unpacking liability related to the use of premises, known as occupier's liability, then dipping into nuisance, the rule in Rylands versus Fletcher, and wrapping up with the fascinating topic of privacy. I am Theo, and I am joined by Anna, my wonderful co-host.
Sounds like a full house. And just to clarify, this is all super relevant for anyone studying for a law degree or gearing up for the SQE, like me.
Exactly. And we would like to thank Dr. Yannis for putting together the material for today's podcast. Now, let's start by clarifying a key point: the difference between claims based on damage to property and those stemming from defects in the property itself.
Right. That seems like a pretty foundational distinction. So what's the big deal?
The big deal is it sets the stage for evaluating the so-called complex structure approach and looking into landmark cases like D&F Estates versus Church Commissioners, 1989, Ans versus Merton, 1978, and Murphy versus Brentwood, 1990. We also need to understand what the law says about spending money to prevent damage before it even happens.
Okay, so physical damage to property is generally something the law wants to compensate for, yeah?
Spot on. That's the default in tort law, assuming other conditions for recovery are met. You'll often see this in nuisance claims, where property use is interfered with, like when a neighbor's factory sends over some lovely pungent smells.
Delightful. But if it's just a dodgy bit of plaster or a building defect and nothing's actually damaged, we're in contract law territory.
Correct. Tort law doesn't usually touch defects that haven't caused additional harm. For instance, buying a flat with shoddy insulation, that's a contract issue. Unless that defect causes water damage to the neighbor's flat. Then we're talking tort.
So what happened in Ans versus Merton?
In Ans, a block of flats developed cracks from shallow foundations. Even though the local council had approved the plans, the court said fixing the building counted as compensable physical damage. That extended the duty of care quite a bit.
But then later courts backtracked, didn't they?
They did. In D&F, the Lords decided that a badly plastered wall wasn't enough for a tort claim. No damage beyond the wall itself, no tort. Then, in Murphy versus Brentwood, they reinforced that, saying approving dodgy plans doesn't make a council liable unless someone or something else gets hurt.
Ah, that whole pure economic loss line. The courts really don't want tort law morphine into contract law.
Exactly. That's where the complex structure theory tried to get creative. The idea was that you could view a building as lots of little parts, so if a boiler exploded, that damage could count as separate from the defect itself.
Clever, but sounds like it didn't fly.
For the most part, no. The Lords decided that for a standard house, you can't treat it like a Lego set. It's an integrated structure. They did, however, leave the door slightly ajar, suggesting the theory might apply in very specific cases, like a complex commercial building with distinct elements built by different specialist contractors. But for everyday property, the idea was rejected.
Fair enough. So the current law draws a pretty firm line, doesn't it?
It does. Unless a defect causes harm to someone or something else, it's not tort. It's a loss in value. That's a contract matter. One exception? The Defective Premises Act 1972. It makes builders and developers responsible for doing their job properly, using the right materials, and delivering something fit for habitation.
Got it. So it's about drawing the line between personal safety and your investment going a bit south. Ready to switch gears?
Let's. Next up, occupier's liability. We're talking about who's allowed onto property and what duties are owed to them.
Like, who counts as a visitor and who's a trespasser?
Exactly. The Occupier's Liability Acts of 1957 and 1984 codify these duties. 1957 covers lawful visitors, those invited or allowed in. 1984 deals with trespassers and other unauthorized entrants.
So what's the main difference in duty owed?
Lawful visitors get the common duty of care. Basically, take reasonable care so they don't get hurt. Trespassers, they get a more limited duty, just enough to avoid obvious, serious harm if the occupier knows or should know there's a risk.
Sounds fair. And who's actually considered the occupier?
Not necessarily the owner. It's whoever has control of the premises. So a pub manager could be an occupier, just like the owner. Classic case, Wheat v. E.L. Lacan and Co.
And what counts as the premises?
Pretty broad. Even a ladder, according to Wheeler v. Copus. If it's part of the property or used on it, it can count.
Let's talk warnings. If I put up a "Beware the dog" sign, am I off the hook?
Only if the warning is adequate. It has to actually help someone avoid the danger. If it's just for show, it won't do much legally.
Kids must be a special category, right?
They are. Occupiers owe a higher duty because kids are naturally curious and don't spot risks as easily. But courts also expect parents to do their part.
Fair enough. And what about professionals like electricians or builders?
They're expected to protect themselves against the risks of their job, unless the occupier does something really negligent. Those professionals usually bear the responsibility.
Great, that's clear. Let's keep going. Nuisance next?
Yep. We'll explain the difference between private and public nuisance, how the Human Rights Act fits in, and wrap it up with remedies like injunctions and damages. Ready?
Ready as I'll ever be. So, what exactly is nuisance?
Great question. Nuisance in tort law is all about protecting people in their enjoyment of land. There are two types, private and public. Private nuisance is interference with the use or enjoyment of your land. Public nuisance is broader. It affects a group or the public at large.
Okay, so private nuisance is like if my neighbor keeps playing death metal at 2 a.m.
Exactly. That could interfere with your use of your home. But it's not just noise. Odors, smoke, and even vibrations can count. The key is whether the interference is unreasonable.
How do courts decide what's unreasonable? I mean, I might like death metal.
They look at a few things. What's the character of the neighborhood? How long and how often is the interference? Was there any malice? They weigh all that up. Living next to a farm is different from living next to a library.
Makes sense. But if I move next to a pre-existing factory or nightclub and then start complaining about the noise, surely that's my fault. I won't get very far, right?
You'd think so, and that used to be the case. It was a defense called coming to the nuisance. But this is a crucial point for students to get right. The law has changed significantly here. The Supreme Court in Coventry v. Lawrence, 2014, effectively abolished that defense.
Oh, wow. So you can move to the nuisance and complain.
Exactly. The court decided that a claimant's right to enjoy their land shouldn't be automatically defeated just because they arrived after the nuisance started. The character of the neighborhood is still relevant in deciding if the activity is a nuisance in the first place. But the defendant can no longer simply say, "You came here, so you have to put up with it."
Got it. So what if the nuisance comes from something natural, like tree roots from a neighboring property wrecking my driveway?
Even natural causes can lead to liability if the occupier knew or ought to have known about the risk and did nothing. The classic case here is Leakey versus National Trust. They were held liable for not dealing with a natural mound of earth that caused a landslide.
And public nuisance, how does that work?
Public nuisance usually involves obstruction of highways, pollution, things that affect the public as a whole. To sue, you normally need to show you've suffered special damage, harm over and above the general public, like personal injury or property damage. It is worth noting, though, that since the case of Hunter v. Canary Wharf, there's some doubt about using public nuisance for personal injury claims. The courts now prefer those claims to be brought in negligence.
So if a burst sewer floods my house and half the street, I might have a claim.
You might, especially if it can be shown the authority knew about the issue and failed to act. But for personal claims under public nuisance, you have to prove that special damage.
What about remedies? I'm guessing damages and injunctions?
Correct. Injunctions stop the nuisance from continuing, and damages compensate for the harm already done. Courts have to perform a balancing act, weighing the public benefit of the activity against the private discomfort. A classic, though complex example is Miller versus Jackson.
Yes, the flying cricket balls from the village green.
That's the one. And it's a common misconception that the cricket club won.
The court actually found them liable for both nuisance and negligence. However, they refused to grant an injunction to stop the cricket, partly due to the public interest in the club. Instead, they ordered the club to pay the claimant damages. So the club was liable, but allowed to continue playing. It highlights the flexibility of the available remedies.
Okay, let's move on. You mentioned Rylands versus Fletcher earlier.
Yep. It's a kind of strict liability tort, meaning liability without negligence. If you keep something on your land that's likely to cause harm if it escapes, and it does escape, you could be liable.
So, if I keep a massive water tank in my garden and it bursts, flooding next door?
That's classic Rylands. You'd likely be liable, even if you weren't careless. But there are exceptions like acts of God, consent of the claimant, or if the escape was due to a third party.
And how's this different from nuisance or negligence?
Good question. Nuisance is usually ongoing and affects enjoyment. Rylands is a one-off escape of a dangerous thing. And negligence requires a breach of duty. Rylands doesn't, just the escape and the damage.
Is it still used much?
Less than before, especially with developments in environmental regulation and human rights law, but it's still valid, especially for things like chemical spills.
All right, last topic, privacy. How does that fit into tort?
It's a relatively new development. Traditionally, English law didn't recognize a standalone tort of privacy. But with the Human Rights Act 1998, especially Article 8, respect for private and family life, things have changed.
So, can I sue someone for taking sneaky photos of me in my garden?
Possibly yes, especially after Campbell versus MGN, where Naomi Campbell successfully sued for publication of private information. The courts now use a two-stage test. Does the person have a reasonable expectation of privacy, and is that outweighed by the public interest in freedom of expression under Article 10?
That sounds kind of flexible.
It is. It's a balancing act. If the press has a strong public interest argument, they might win. But if it's just gossip, the claimant usually prevails.
So, no more tabloid ambushes?
Well, fewer. And remember, this area of law is now known as misuse of private information. From a technical standpoint, the courts didn't create a brand new tort of privacy. Instead, they expanded the existing equitable action for breach of confidence. But in practice, it functions as an actionable tort that protects privacy. It's a key part of the wider shift, recognizing autonomy, dignity, and personal boundaries in tort law.
That's quite a journey from dodgy plaster to privacy rights.
It is. Tort law might seem like just rules on accidents and nuisances, but it's constantly evolving with society. Whether you're prepping for the SQE or just trying to make sense of it all, these principles form the backbone of how the law handles harm.
Thanks for breaking it down. And for anyone listening, don't forget to subscribe to Dr. Yannis' newsletter, check out the YouTube channel, and hit like so more SQE hopefuls can find this.
Thanks for tuning in. See you in the next episode.